Hello, everyone, and welcome to today's webinar. Thank you very much for joining. My name is Stacey Sinclair, and we are very delighted to be back with you today after our short break in August. So today we are, of course, speaking about design liability, and particularly in respect of site constraints and ground conditions. This is a topic that continues to plague the construction industry and engineering projects. And we therefore felt it might be useful to review the law in this area, what the standard form contracts say, and some practical tips that one needs to consider. So our speakers today, we have Jeremy Glover, Fenwick Elliott's partner, who of course specializes in all things construction law, who is also the president of Region 2 of the Dispute Resolution Board Foundation. And of course, many of you will know him from our previous webinars, as Jeremy is a co-organizer of this series. And as you can see, alongside Jeremy, we have Kort Egan of Gatehouse Chambers, which is formerly Hardwick Chambers. Many of you might have been expecting David Pleener today when you registered. Something unfortunately has come up, but we are very grateful and very delighted that Kort is able to join us and take his place. Kort also, of course, specializes in construction and engineering law, and he's certainly a rising star. I also must add that the one thing that Kort and Jeremy have in common is their passion for the FIDIC contract. Jeremy is the co-author of Understanding the FIDIC Red and Yellow books, a book which Kort has made significant contributions to. So before I hand over to our speakers, let's cover a few admin points. Of course, everyone is on mute. And may I encourage you to ask questions as we go. I'm sure you will have found by now the questions box in the toolbar on the right-hand side of your screen. And do ask as we go, and I will put as many questions as I can to the speakers at the end. Also, rest assured, this webinar is being recorded, and a copy of this webinar will be available on demand along with the slides on our website afterwards. And I believe you will see in the chat box a link to, or in the questions box, whichever, a link to where you will find those shortly after the session today. So with that, I shall hand over to you, Jeremy. Thank you.
That's excellent. Thank you very much, Stacey, and welcome to everyone. So as Stacey said, we're going to be looking at the approach to liability for site conditions, liability for ground conditions, and so we'll be looking at risk allocation, questions of design liability, what are unforeseeable ground conditions, and we're looking at the approach of the standard forms. But I want to start by having a quick look at risk allocation. What is it all about? What is the employer, what is everyone, to be fair, really secretly thinking? Well, as you can see from the slide, what does the employer, what do they really want? They want the building for the lowest price in the shortest possible time. They want control. Do they want responsibility? Well, they like the idea of single point responsibility, perhaps as long as it's not theirs. And what about the designer? Well, they're interested in the design. They're interested in the end product. Cost, oh, well, that's for someone else. And they're well aware that their own fees are going to be pared to the bone. And the contractor, well, they want jobs. They want turnover. Maybe acceptance of design responsibility brings the opportunity to design a structure which can be built more quickly, can be built more cheaply. Are they resourced enough? Well, of course they are resourced enough. And of course there may only be elements of truth in the bullets on the 3 slides that we've gone through. But when it comes to risk, when it comes to allocating risk for contracts, you need to be thinking about everything. You need to be thinking about what your role is and how that's going to be impacted on the project. And you need to be thinking about what everyone else is going to have in mind too. And you also need to be looking at the more serious stuff, the causes of claims. Now, of course, there's lots of research about the causes of claims. The results of the research of Howell and Metropolis research carried out almost 30 years ago now, and they talked about project uncertainty. Things become more complex. They talked about process problems, questions in relation to unrealistic expectations, the possibility of there being incomplete documentation. And that's something that both myself and Kort will touch on as we go through the rest of the webinar today. And then there's the unknown, the unpredictable, people, communication. Do they talk to one another? Those of you who've attended other webinars in our series over the past 18 months or so will be well aware that various speakers have stressed the importance of communication, the old-fashioned idea of actually speaking to one another. So when it comes to risk allocation, well, what should be happening? Well, in theory, well, think about the apportionment of design risk between the employer and the contractor. It's something that's going to arise in every construction project. You inevitably find that the employer, even if they're acting upon the advice of consultants, and the contractor will both, to a lesser or greater extent, be responsible for some element of the design. And any uncertainty about the meaning or ambit of the liability for design, any uncertainty about the meaning of the terms being used can be a major source of risk, which is why it's important that risk is identified. People should be taking conscious decisions about how each risk should be managed. It almost goes without saying this needs to be done in a clear, unambiguous way, particularly when you're dealing with the more significant risks. And quite often, ground conditions is one of the more significant risks. And of course, contracts should be recording exactly what the parties intend. Now, if you don't expressly deal with risk allocation in your contract, or if the standard form you're using doesn't deal with risk allocation, then if you're in the UK, you'll find that you're bound by what the common law says. And you'll find that the common law takes a very firm view on the allocation of risk. And we'll come on in a minute to what that view is when it comes to dealing with ground conditions. But perhaps the final thing that you should be thinking about in theory when it comes to allocation of risk is have a look at Niall Booney's 4 principles for allocating risks. Which party can best control the risk? Which party can best foresee the risk? Who can best bear that risk? And who ultimately benefits the most or will suffer the most when the risk eventuates? And if you can actually answer those questions, that goes a long way to deciding how risk should be allocated on a sort of fair approach when it comes to setting out the terms or drafting and finalising your contract. So they are some of the things that you need to be thinking about when you're considering allocation of risk. And these are some of the things that we're going to be highlighting over the next 25 minutes or so as we delve deeper, dig a little bit deeper into questions in relation to ground conditions. And Kort is going to start us off by discussing some issues in relation to design liability. So Kort, over to you.
Thank you. As Jeremy said, I'm going to be talking about design liability and potential pitfalls in respect of it. In particular, I'm going to be talking very briefly about what design liability is. Then I'm going to be talking about the importance of design liability being appropriately passed down the chain. And finally, the importance of clarity in respect of design obligation or design obligations that are imposed. So beginning with design liability, what are we actually talking about? Well, we're talking about who bears the legal responsibility for all or part of the design of a construction or an engineering project. Now, that's particularly important in construction projects because they're often multi-layered and they're often multi-party, i.e. you have consultants, contractors, subcontractors, and that often means that in practice it's difficult to actually ascertain at times where design liability is meant to lie. And that brings me on to this question about the importance of design liability being appropriately passed down the chain. Now, this is actually something that I've got lived experience of, in that in a recent case I had, you had a situation where you had an employer and a main contractor who'd agreed a contract pursuant to which the main contractor bore design responsibility. Then the main contractor had sought to subcontract design, but had been unable to agree a formal subcontract with its subcontractor, and instead a contract had to be pieced together on the basis of correspondence, and inevitably that's led to a dispute as to whether the design, an issue has occurred with it which has caused substantial loss, and now inevitably there's a dispute about whether the subcontractor has any responsibility for design or not. And as I say in that first bullet point there, the issue is that in a circumstance such as that, the main contractor is placed in a situation whereby it may be held solely responsible for the design, even though its intention all along was to pass the design to its subcontractor. And in terms of the second bullet point there, as I've just described, that case that I've just talked about is going to run and run, and inevitably it's caused the parties costs, uncertainty, time, which could have been avoided if the importance of design liability being passed down the chain had been borne in mind from the outset. Moving on to another potential pitfall and something to be borne in mind is the need for clarity in respect of the design obligations that are intended to be imposed on a party. The main headline in respect of that is that the precise wording used in the contract is going to be absolutely key. I'm going to look at the case of MT Hogarth that ended up in the Supreme Court in 2017 to talk about the importance of getting the contract right and as the parties intend. In terms of the background to the case, well, MT Hogarth was the design and build contractor of the foundations of a wind farm, and the wind farm was to be built in accordance with an offshore code, which I'll refer to as J101. It was subsequently discovered that the code had an inherent problem that meant that anything designed in accordance with the code would be bound to fail. Now, the parties had agreed the cost of the remedial works, but they decided to leave it up to the court to effectively interpret the contract to see where liability would lie. And the contract itself, now, you had what I would call a mixed contract here, in that you had the general obligations in the conditions of the contract require the contractor to design with due care and diligence, and then use standard wording in respect of a reasonable skill and care clause, i.e. due care and diligence expected of appropriately qualified and experienced designers. The difference was that in this case, in the technical requirements, it was stated the design of the foundations shall ensure a lifetime of 20 years in every aspect without planned replacement. Now, the question for the court to consider was whether MTH had warranted a 20-year lifetime for the foundations, or only had to design with due care and diligence, i.e. the question is, which obligation takes precedence, or how do you make them cohere? Now, the lower courts took different views on what the correct answer was. Mr. Justice Edward Stewart, at first instance, held that MTH was responsible for the rectification work, as he held that there was a breach of a fitness for purpose obligation. The Court of Appeal disagreed with that analysis, and importantly, because this is an argument that has run and run and still provokes dispute today, the Court of Appeal said that the technical requirements were too slender a thread upon which to hang a finding that MTH had warranted a 20-year lifetime for the foundations. Now, the case came before the Supreme Court, and to cut matters short, they decided to overturn the Court of Appeal, but the analysis of Lord Nuremberg in particular is enlightening. He noted at the start that the contract stated that the requirement to comply with J101 was a, quote, minimum requirement. And he held that in a situation where you have two provisions that impose different or inconsistent standards, it's possible to construe them, and they should be construed in the sense that the more rigorous must prevail and the less rigorous can be treated as a minimum requirement. Lord Neuberger also rejected the Court of Appeal's conclusion that the technical requirement was too slender a thread, and he applied an ordinary contractual approach. In particular, the statement at paragraph 50 of his judgment, that in my view isn't given sufficient attention, is the statement that it's very difficult to argue that a contractual provision should not be given its ordinary meaning and should instead be given no meaning or a redundant meaning. Because the issue with the contract in that case was that the party was effectively having to argue that the technical requirement, the meaning should either be negated or it should be rendered redundant. And that's just an unattractive approach for a court to take. And it's clear from the judgment that Lord Neuberger was particularly influenced by that. He was thinking, I can't ignore these words, and therefore how do I give effect to them? And therefore his conclusion was that the terms imposed a duty on MTH which involved the foundations having a lifetime of 20 years. So what are the takeaways from that particular case? Well, at that stage, by the time the litigation had crystallized and it was in court, MTH was left to argue that Eon's interpretation was improbable or unbusinesslike. They were also left to argue that the technical requirements were buried in a very lengthy contract and that the general obligations were what the party should or actually did intend. Now, the issue with arguments such as that is that the time for settling any such issues with contractual wording is prior to the execution of the contract. By the time that the dispute had crystallized and was before the court, the wording is as is, and then you're in the hands of the court as to what are they going to do with the natural and ordinary meaning of the words, and how are they going to construe the particular contract that's in front of them. And almost inevitably that can lead to different approaches and arguments and to further dispute. It's also important in respect of insurance to make clear the responsibility owed, because a loss suffered as a result of a fitness for purpose obligation may be uninsured, and therefore for insurance purposes, it's also very important to make absolutely clear the type of obligation that's owed. And in terms of conclusions then about the potential pitfalls for design liability, well, parties have to give real thought to two things. The first thing is, what is the contractual chain and how do we protect ourselves? As Jeremy said, this is a risk allocation point. The parties have to really sit down and consider, where do we want design liability to lie, and have we put in place sufficient protection to ensure that if things go wrong, then we are protected. And secondly, parties have to give real thought to the obligations imposed, i.e., have the obligations that the contract imposes, are those the obligations that were intended to be imposed? As in the MT Hogard case, the point was, by the time it had come to court, the parties were in dispute as to whether that's what they intended or not. And therefore, the real takeaway is clarity and planning as to how parties should contract in order to avoid disputes going forward. And on that note, I'll pass back to Jeremy to talk in particular about ground conditions.
That's great. Thank you very much, Kort. I suppose we're often asked, who takes the risk for unforeseen ground or site conditions encountered by a contractor carrying out works on site? And I suppose, what is the standard position under the standard forms? The answer, unhelpfully, but typically, is that it depends. It has been said it's often as varied as the types of conditions that are actually encountered on sites. But as a general rule, it usually starts with all parties looking at the contractor. Now, as we've said, and as you know, as a general principle, parties to a construction contract are free to allocate risk how they see fit. And so on that basis, rather than look to the basic common law position, that's why parties negotiate contracts. They want to expressly allocate the risk so that everybody knows where they stand, and you don't fall back on the realms of the common law. You don't fall back on the judges. But what is the position under the common law? Well, back in, I think it was 1942, which is almost 80 years ago, there's a case which which very firmly put the risk on the contractor. Expenses incurred for unforeseen difficulties, including ground conditions, must be considered as being included in the amount of the tender. So therefore, the risk very firmly and very clearly under common law falls on the contractor. In promising to undertake the works for the fixed price, the contractor is promising to complete those works, even if those works are more difficult or more expensive, and even if the designs are going to be or have been supplied by the employer. When it comes to the ground conditions, absent other words in the contract, there isn't going to be a warranty for the employer that the designs are feasible. What the employer is doing is relying upon the contractor's professional expertise in determining the buildability of the works. And of course, that's unless the contract says otherwise. So what about the standard forms? Well, the JCT, the majority of the JCT contracts are silent when it comes to the question of ground risk. Therefore, in the UK, when you've got a JCT form of contract, the common law position is going to apply. The risk for unforeseen physical conditions is going to lie with the contractor. That must be intentional. Must be intentional to put the common law position, putting the risk for unforeseen physical conditions with the contractor without any mitigating criteria that you see in some of the other contracts. There is one exception, and that's the JCT Major Project Construction Contract. You've got the clause up there on the screen. Now, that appears to help a contractor. It offers a contractor time and money where they encounter conditions that they could not reasonably have foreseen. But perhaps it only goes halfway there. The adverse conditions encountered must necessitate an amendment to the requirements and or to the contractor's proposals. So it's moving away. It does shift the risk centre a little bit, and it's obviously very different to the approach of the rest of the JCT family, which is why you often get amendments to the JCT standard forms. And one such amendment was discussed in the case of CDL and Eon Energy, and the amendments clauses 2.17 to 9 are up on the screen. These were amendments to the JCT standard building contract for subcontractors. I think it was the version out in 2011. And the intent of those words was to transfer from the contractor to the subcontractor the risk of adverse site conditions that were likely to affect the subcontract works. And I'll come back to this case in a few minutes, and we can have a look to see whether or not the amendments had the effect that that Eon thought that they did. So looking at other standard form contracts, under the NEC form of contract, well, unforeseen ground conditions are a potential compensation event. If the contractor encounters physical conditions which are on the site but not related to the weather, and which an experienced contractor would have judged at the contract date to have a small chance of occurring, such that it would have been unreasonable to have allowed for them, then there's potentially an entitlement to time and money. So here, giving physical conditions as a compensation event, again, it sounds as a beneficial position to the contractor. It's moving the risk away from solely on the contractor, at least. But think about it, it probably is quite a high hurdle for the contractor to leap to get this compensation event. And that's because of the introduction of the concept of foreseeability. Contracts requiring contractors to prove that they, as an experienced contractor, would not have foreseen the conditions which were encountered. But the NEC form's got a very similar approach to the FIDIC form, and given the similarities of the two, I'm going to choose to concentrate on the FIDIC form of contract. You've got up on the screen subclause 4.12 of the Red Book 2017, which talks about unforeseeable physical conditions. You can see that there's a requirement for the contractor to give a capital N notice to the engineer when they encounter these unforeseeable physical conditions. And of course, it wouldn't be a webinar discussing or mentioning FIDIC if we didn't talk about the importance of notices and the importance of getting the notices in on time and following the very strict requirements of the contractors to form of that notice. In other words, a contractor can't rely on informal emails or other site records when it encounters these unforeseeable physical conditions, and they've got to describe the conditions in the notice and explain why the physical condition was unforeseeable, and explain why there may have been an effect on progress or increase the costs. And then the FIDIC form of contract sets out what happens next. The engineer inspects the conditions, contractor complies with instructions, and then there's a review process to see whether there's an entitlement to time and money. Now, if you notice, things are happening very quickly. The engineer inspecting the conditions within 7 days. At one level, that's, I suppose, an example of real-time dispute resolution or dispute avoidance, wanting things to be resolved quickly, but emphasis on the resolved quickly. Unforeseeable physical conditions, you don't want the site necessarily to ground to a halt, because that's going to lead to even more delays. You need to record the position ideally, and then move on and then try and resolve questions of liability and responsibility as quickly as possible. So there are two issues you need to think about: physical conditions and the concept of unforeseeability. The FIDIC form of contract defines physical conditions, natural physical conditions, when natural includes man-made pollutants, conditions that the contractor encounters at the site during the execution of the works. They don't include climatic or weather conditions, so it's similar to the NEC form. And the words in bold are actually the differences between the 1999 form and the 2017 form. So the 2017 form makes it clear that the contract is talking about climatic conditions at this site and the effects of those climatic conditions, those words not being in the 1999 form of contract. Then it comes to the definition of unforeseeable: not reasonably foreseeable by an experienced contractor. So again, it's very similar to the NEC form of contract. And I suppose it might be said that two of any lawyer's favourite phrases are reasonably and experienced, because there's lots of scope for, shall we say, discussion about what those terms might actually mean. And they're certainly not defined here by the FIDIC form of contract. But thinking about it, drilling down to it, the question of what an experienced contractor actually is, it's got to be a question of fact. It's also going to be jurisdiction dependent, but there are 2 or 3 examples from the English courts about what the courts think that an experienced contractor should do, what an experienced contractor should be, particularly when it comes to ground conditions. In the Van Ord case, the courts were clear that an experienced contractor will know that ground investigations are only 100% accurate in the precise location where they are carried out. Now, you might think that that goes without saying, but the point that the court making is the point that's in the second sentence. An experienced contractor fills in the gaps and makes an informed decision about what the likely conditions would be overall. And that's an approach that's followed by Mr. Justice Aikenhead in the Obrascon case. The contractor is experienced, therefore it's got to draw upon its own expertise and experience of previous projects. You can't simply accept the information you're given by an employer during the tender process. You've got to make your own reasonable assessment of what conditions you're likely to encounter. You can't just say, well, I was given these reports and therefore only X, Y, and Z was foreseeable. You've got to make use of your experience. You've got to take a slightly more broad, a much more informed view. And drilling down a little bit on what Mr. Justice Aikenhead was saying you don't limit yourself to the analysis that you're provided with. You've got to carry out, you've got to think about it. They're looking for an intelligent assessment of an analysis of why, and in the case of the Abrascon case, there was contamination. And the judge was saying, well, there are obvious questions which experienced contractors should be asking. If you've got a brownfield site and lots and lots and lots of projects are built on brownfield sites, well, an obvious question is, what was this site used for before? I think in the Abrascon case, there was something to do with military. And so there were lots of shell casings and other types of contaminants and pollutants available. And to be honest, that's quite an obvious question that the judge is asking. And it's interesting that that's an example of what an experienced contractor would do. You might think, or you might say, that any contractor should be thinking about. And again, questions like this came to the fore in a more recent case involving PBS and Besta. It's not enough to simply say, well, there was more asbestos than the previous reports had suggested. Asbestos wasn't a possibility. Asbestos contamination was a reality. It should have been obvious from the reports. So as I've said, the contractor can't be relying on an argument claiming that the investigations they were given were 100% complete. What matters is the information that they're given themselves. Is the information such as to put the experienced contractor on inquiry so that he can only complain if what emerges is unforeseeable in light of what they do have? So when you've got your contract, which talks about foreseeability, it talks about what an experienced contractor must do. Well, the experienced contractor's got to read the information they're provided with pre-tender. They've got to make sure they go on any site visit that they are invited to go on. They need to think, and then they need to think about what they don't have. What parts of the site did they not see? And then they need to think about whether there are any lines of inquiry. What hints potentially are being given in the information they had that suggests that there may be different ground conditions in parts of the site that they haven't been able to access. It might also be worth recording for your own records the decisions that are being made pre-tender about what the ground conditions are likely to be, because then you have an explanation of what you did actually foresee at the time of entering into the tender. And in determining whether the contractor is entitled to additional time and money in respect of overcoming the unexpected site conditions, you've also got to consider whether the additional work was actually part of the original scope. Now that's going to involve an analysis of the description of the works in the technical documents, as well as considering the risks that a contractor has assumed under the contract, whether or not the contractor is required to undertake work that is additional to that described in the specification. And so the design obligations that Kort has talked about and the buildability obligations that a contractor has undertaken are going to be key factors which need to be considered when considering the extent of the works, considering whether there is liability for the adverse ground conditions. And that's what takes us back to the Clancy case. So what happened here in the subcontract? We've seen the amendments which shifted the risk to CDL. But in the subcontract, the works were described as being the works referred to in the subcontract agreement, and those works described in the numbered documents. So the subcontract agreement was the document which, as we've seen, expressly allocated the risks of ground conditions to CDL, but the numbered documents included tender clarifications where CDL set out what work was included and what work was excluded. And by the numbered documents and the description of the works in the contract, the scope of the works under the subcontract had been modified by the appended documents. Now, if you remember what Kort was saying about paragraph 50 of Lord Neuberger's judgment in MTH, you can't ignore words that are written in a contract. You couldn't here ignore the words described in the numbered documents and ignore the words that were then found in those numbered documents. So although Eon had amended the contract to put the risk on CDL, CDL, by the clarifications they'd had by excluding certain works from their ambit, had actually moved and had taken away from themselves the taking on board the risk for ground conditions. So CDL were not responsible for the ground conditions in that case. So what I think myself and Kort, what we've been saying this morning, is the need to consider carefully each and every document that's included within the contract. Sometimes if there's going to be a question of conflict, what's the order of precedence of those documents? But as Kort was saying, understand before you sign the document or conclude the documents what's there and what risks are being allocated. Check that terms are consistent with other contract documents. How clear is the risk allocation? Is there a clear definition of the scope of works? And that's what, an issue that was in the CDL and the Clancy case. And that's because ultimately, although people talk about, the experienced contractor and they talk about foreseeability, the secondary issue that's quite often forgotten was whether the additional work involved was actually a part of the original scope. But I think I've used the word clear 2 or 3 times in that final slide. And because that is the key takeaway, parties are free to allocate risk as they see. The more carefully it's done, the more it is done in a clear manner so everyone understands what has been decided, the less scope there is actually for disputes. So that's the come to an end to some of the issues that we wanted to raise with you this morning. So Stacey, I don't know if there's been any questions that have come in.
Thank you, Jeremy and Kort. That's been a very, as Jeremy, as you said, clear and really helpful run through of the area, which can be particularly tricky. And there have been a number of questions that have come in. We have a very large audience today, and thank you to everyone for submitting such fantastic questions. And our apologies in advance if we cannot get to all of them, which we clearly cannot. But I will ask our speakers, Kort and Jeremy, to follow up afterwards with you. So, Kort, we've had a number of questions come in about the MTH case, a lot which are particularly detailed. But I'm going to ask an overall question. Did the Supreme Court get it right in MTH?
Well, I think they got it right in the sense that is the judgment, and we're stuck with it in a sense. My own personal view, and obviously I may well argue the opposite at some stage in the future, so don't hold me to this, is that it was correct, because I'm what I would call a traditional contract lawyer, and I look at whatever the natural and ordinary meanings of the words involved are, and that's what I take as my starting point. I think my own point of view is that the case really will probably be, to be flippant, consigned to the ash heap of history quite quickly, just because you've already seen from cases like Blackpool Borough Council and Volker Fitzpatrick that in that case the judge basically said that the case is confined to the particular words of the contract, and that's always going to be the case. So MT Hogard was a decision on the particular contractual provisions found in that contract. And obviously, if there are any even minor changes to the wording of the contract, the outcome might have been different. For example, if the word minimum requirement hadn't been there in caps, who knows what the outcome would have been, whether that would have made any difference. So my answer is I think it was decided correctly, but it all depends on the contract.
Well, I might differ slightly. I mean, I've always been a great fan of Lord Justice Jackson anyway. But I mean, I think the practical common sense approach he took when he talked about the liability being sort of too slender approach was perhaps the fair result. But of course, as Kort says, what the Supreme Court says goes. And so ultimately, I suppose it doesn't matter what we think. What matters is what the Supreme Court says. But there was once, I mean, it was a few years back when I was in Dubai at a conference. It was between the time of the interregnum bit, where between the Court of Appeal and the Supreme Court decision, and the case was put forward as an anonymised case study, and people in the audience were asked what they thought the answer should be. Effectively, is it Court of Appeal or is it Supreme Court? What was interesting was that broadly the audience fell into two categories. Those that were largely common law background tended to side with the Court of Appeal approach, and those with the more civil law background tended to favour what became the Supreme Court judgment. And I'm a common law lawyer, so I stand with Lord Justice Jackson. But anyway, that's only my personal view, and as Court says, what matters is what the Supreme Court said.
Thank you both. That's great to hear the two sides of it. The now a number of questions, Jeremy, around foreseeability. So I'm going to try and capture them in one go here. Given the definition of unforeseeable refers to experienced contractor, isn't the reality that the experienced contractor should be able to foresee everything? Shouldn't they should have seen or experienced it all before? And one step further, how can you suggest how do you demonstrate foreseeability?
Yes, that's a good question, and I can see very much why it's been asked, because yes, as the questioner said, the experienced contractor's been there, done it, therefore knows everything. The reason I don't think that quite works is because, I suppose ultimately it goes back to taking from the point Court made again about paragraph 50 of the judgment. The words are in the contract for a reason. You don't put words in a contract which, I suppose, lessen the liability of the contractor, or potentially give the contractor a route to escape liability, as it were, unless you think that they can. And therefore, I don't think experienced is a complete get out for the employer in the way that the questioner has said. How do you, it comes back to looking at the points that were raised in the judgments that we looked at. It's for a contractor to demonstrate that they did act in an experienced way. They did take steps to consider the information. They used their experience. And even though they had done that, these things happened. This thing occurred, and they couldn't have foreseen it. So it's almost being able to document the steps that you've done. And that's why I mentioned, well, it might be quite sensible at the time to just keep a note of what your views are, having read the technical documentation, or having gone to the site visits, of what the potential risks are. It's not a catch-all. It shouldn't catch everyone, because things happen. You've just got to demonstrate how you used your experience to foresee what the risks might be, and then something else happens. I think that's the way you need to treat it.
Perfect. Thanks, Jeremy. We've got a lot of questions here around very detailed, specific matters to people's projects and things. If we take this a bit more generally for the moment, Jeremy or Kort, do you have any, what are some of the practical matters that our audience and parties could consider when investigating ground conditions?
Well, I think to begin with, as Jeremy mentioned, the case law is absolutely clear as a starting point that it's important for a contractor to satisfy itself as to the ground conditions, i.e. they shouldn't simply rely on any inherited information and rest on that and not carry out any of their own investigations. It's important for them to be active in the process rather than passive. In terms of the actual standard or degree of investigation that's required in order to provide a prudent assessment, then inevitably that's going to rest on the facts of the case. So some particular factors considered are obviously the nature of the works being undertaken. That's key. because that's going to have an impact on the particular relevance of the ground conditions. The historical use of the sites is another factor. As Jeremy mentioned, one of the key points in the Obrascon case was the fact that the site's historical use in the 19th century was as a rifle range, and that was actually one of the key factors in determining whether the ground conditions were unforeseen and how they were dealt with under the building contract. Evidence of previous incidents is obviously very important, so any evidence of landslips or subsidence, and then also the site's proximity to other buildings and the use of those other buildings. And contractors obviously also have to bear in mind what's necessary for this particular project to get to the bottom of it. So are we going to have to do what I would call more complex processes such as borehole surveys or laboratory tests? So those are some of the factors I would say that have to be borne in mind, but inevitably it depends on the particular facts of the case, what is going to be necessary.
Thank you, Kort.
Yeah, I've got nothing to add. That answers the question perfectly.
Yeah, perfect. Thank you, Kort. Again, lots of brilliant questions streaming in here. A number of people are asking about the slides and a recording of this. Absolutely. These will be, the recording and the slides will be available on our website in due course. And I think that there is a link in the chat or the questions. So rest assured. And as I mentioned previously, Kort and Jeremy I think will do their best because of all the questions coming in, if we can possibly get back to you direct. So apologies, we have not been able to get to all of the brilliant questions you've submitted in the time. But I think we are going to need to end there. But of course, in the usual way, if I could mention next week's webinar first. Sorry, 2 weeks time, on the 30th of September. We have inflation and material shortages, protecting your position, a very timely topic in the current environment. And we have Fenwick Elliott partners Claire King and David Bebb, who will be here to deliver that for you. But Kort, Jeremy, thank you very much for covering such an expansive topic. And thank you very much to our audience again for joining us and being back here again with us today. And we very much look forward to seeing you either in 2 weeks' time or on our future webinars. So thank you very much, everyone. And I hope you have a great rest of the day. Thank you.
Thank you.